Good morning. Welcome to a discussion on managing expert evidence, tips and best practices. I am Ishani, Vora, Senior Director with FTI Consulting and a damages quantum expert. With me today, I have a group of stellar panelists with diverse backgrounds to give us a well-rounded insight on this extremely relevant topic. Our panelists need no introduction, so I'll try to keep this very quick. I'll start with Shreya. Shreya is a Principal Associate in the International Arbitration Practice at Shardula Marshal Mangaldas in Mumbai. Shreya's experience includes international commercial and investment treaty arbitrations with major international arbitration rules like ICC, CAC, LCIA, Ancestral, ICSID, etc. in sectors such as energy, finance, commodities, construction, public utilities, consumer products, and insurance. Previously, she worked in the international arbitration practice at Cooley LLP in New York. She is an active member of various international arbitration organizations and currently serves as the India co-chair of Young ITA and a regional representative at the LCIA's Young International Arbitration Group, along with an assistant editor of the Cluo Arbitration blog. Welcome, Shreya. Next, I'll go to Vikas. Vikas is a partner in the arbitration practice at Keystone Partners with experience handling domestic and international commercial arbitrations conducted under the ICC, CAC, LCIA, and QICCA rules, among others. He specializes in infra and technology-related disputes. Before joining Keystone, Vikas worked for over 6 years in the arbitration team at Herbert Smith, London, Paris, and Singapore offices. Vikas is a member of the Chartered Institute of Arbitrators and a part of the panel or list of arbitrators at institutions such as LCIA, CAC, HKIAC, EBRAMS, and IIAC, among others. Vikas is also a convener at the India Arbitration Forum and an advisor to the Center for Online Resolution of Disputes and Terrace, an arbitration technology and transcription service provider. You can see their transcription live actually. Welcome, Vikas. Next, I'll go to Ben. Ben is a head of dispute resolution at Fox Williams LLP in London. He has been working in international arbitration for over 20 years as counsel and arbitrator. He is a chartered arbitrator and a member of the Global Board of Trustees of the Chartered Institute of Arbitrators. He is also on the board of directors of London International Disputes Week and on the advisory board of the London Chamber of Arbitration and Mediation. Currently based in London, Ben was based in Singapore for 7 years and he has extensive experience of India-related arbitration seated in Singapore. In fact, he's currently working on 2 matters seated in Singapore but India-related. He has been recognized by Who's Who Legal as a thought leader and a global leader and a leading individual by Legal 500. Welcome, Ben. And last but absolutely not the least, we have Neeti, who is the Secretary General and a Registrar at MCIA. Previously, Neeti worked with top-tier law firms like Trilegal and ELP and with the International Arbitration Department of Freshfields in their Paris office. Neeti also worked with LCIA India as its first Deputy Registrar. She is an office bearer at the IBA Arbitration Committee and regularly sits as an arbitrator. Welcome, Neeti. Okay, I'm just very conscious of time, so I will jump into the topics we want to cover. I just want to spend a few seconds to talk about housekeeping. We'll do a few questions with the panelists and then we'll open the floor to the audience. We are expecting our chief guest, Honorable Justice Dangre, to give her address at around 9:30, so we'll try to wrap up by then. Okay, so getting into it, the dictionary.
They will basically hear us till she doesn't come.
Yes. So, okay, getting into it, the dictionary defines an expert as a person with special knowledge, skill or training in something. In the context of disputes, experts or expert witnesses come in variety of forms. So depending on the context of an arbitration, you could have experts who specialize in industries, for example, technology, infrastructure, or oil and gas, etc. Or you could have skill experts like valuation experts, accountants, technical experts, delay experts, etc. So, such experts can offer evidence or analysis which helps with facts and breaches and assessing damages and so all the aspects of an arbitration from law, fact, and then final outcome in commercial arbitrations. For example, some of the questions put to experts like me who specialize in damages are valuation of shares, businesses, lost profits, analyzing costs, effect of values of patent and IP infringement, and effect of disruption delays. The use of expert witnesses in international arbitration has been on the rise over the years, at least in the context of international arbitration. I'll now move on to the panel and I'll stop talking. I'll first go to Neeti, since you are here. Okay, can I ask you an opening question? What do you think has been the role of experts and how have you seen it evolve over the years, both in international arbitrations and to the extent you've seen it in domestic, but in India?
Thank you, Ishani. I think I should thank FTI because this is the first time that somebody's invited me to speak at the India ATR week. So I was very excited. I said, Ishani, I'll definitely take it because otherwise you're always on the other side organizing it, and left it happily on Madhukesh to take care of these 2 hours. So thank you on that. I think the evolving role of experts as I see is that it's evolving, but it's very slow paced. One would like to see it more. I always compare it to akin to institutional arbitration in India, which is evolving, but is again very, very slow paced. Of course, experts play a very crucial role in an arbitration, and I think none of us in this room can deny that fact. But there is a reluctance, a hesitant always to get them in at the right time. I think there are a couple of things evolved with that, right? I distinguish it in 2 ways. One is to say that where the evolving role of experts is coming, you divide on the basis of what the claim is and how sophisticated your client is. So if you have a very small value claims, you will hardly see an expert coming in. And sometimes for large value claims as well, if the client is not very sophisticated or doesn't want to listen to their lawyers, which sometimes they don't, then you don't see experts coming in at the right time. Timing of the experts is what I think is evolving. We always saw that you would have an expert who would come in at the fag end of after the pleadings have been filed, and you're now in the stage of filing your witness statements, expert statements, and then you will just call up an expert and say, okay, this is what I filed, that's what my statement of claim and defense is, can you just help us with that? I think that is what I've seen more, at least in my experience, that is evolving, that while the parties are drafting the claims itself, that they get approached to, they approach the experts much more in that.
I think I absolutely agree with that. The experience we've had is very similar. When we started, we used to only do work right at the time, when the reports are due in like a few weeks. And now we see a lot of lawyers, counsel, parties approach us even as early as when they're looking for funding, for example. And that's a great change. I think that has definitely benefited at least the matters we worked on. Thanks for that, Neeti. Ben, can I come to you now and ask you, when you're looking for experts, what are the qualities you look for? And how much emphasis do you place, say, for example, on geographic familiarity or industry familiarity as opposed to expertise in the work itself?
Thank you very much, and good morning, everyone. Thank you very much for coming at this early hour. Let's start by saying that, of course, as we all know, there's not just one expert in an international commercial arbitration. There are actually 4 experts. And in many ways, the most important expert is the person within the client. I mean, if you're working on, for example, a road project or a construction project, that client will have engineers in-house. Those engineers would have worked on the project for 5 years or whatever. They will know it inside out. They will be extraordinarily expert in the matter. Then a second expert is actually the lawyers. The lawyers become expert in the matter as you move along. They become an expert in a very small way. I worked on a matter for about 5 years, which is all about a telecommunications satellite. And the dispute was about the thrusters on this telecommunications satellite. And the thrusters are essential in space, I can tell you because I'm an expert in it now, in terms of positioning the satellite to get in the right position. And for a while, I knew, after working on this case for 5 years, I knew everything that there is to know about thrusters, and in particular, the fuel nozzle into a thruster. I knew nothing about the rest of the satellite. I couldn't tell you what it did. I couldn't tell you how it got there into space, but I knew an awful lot about this fuel line into the thrusters. The third expert in international arbitration are the arbitrators. And the arbitrators are the ones, ultimately, who you want to become the experts. You want them to know what these thrusters are about. You want them to know the expertise at the end of the day. And then you get to the fourth expert, who are the testifying experts, and that's who we're talking about here. That's one one not normally refers to when you refer to experts. And this testifying expert has their role in many ways is to perform the shift from expert number one to expert number 2 and 3. They are there to help take that knowledge from the in-house person to the lawyers, to the arbitrators, and explain in clear terms what's going on. And of course, we go to people like that because they are regarded as perhaps a little less expert than the in-house person, but a little more independent. And to go back to your question, we're looking for someone who's able to perform that role, who's able to come in and explain things clearly, who's able to educate, who's able to work with the lawyers, because we're not just talking about performing giving evidence on one day at the end of arbitration, but actually talking about sitting down with the lawyers over a period of months, even years, to explain what's going on. And then at the end of that process to give evidence. So we're looking for someone, it's quite a rare set of skills actually, to be able to come in with that knowledge of many years of working in a particular sector, but also to be able to explain and educate and convey the truth of what's going on to these other people and to educate them. And in terms of geographical expertise, well, I mean, again, it depends on what we're talking about. The satellites case I referred to, there are only a few places in the world where you can go for satellite expertise, and we had to go to all these people who were ex-NASA, and they're all now in Bethesda, on the outskirts of Washington. I mean, it seems to me that's the only place in the world where you can find satellite experts. And the Americans, of course, are incredibly anxious about the release of the technology, so you have to sign all sorts of documents and sign up to ITA and everything else. It's really difficult. On the other hand, if we're talking about commercial expertise, accountancy expertise, there are, to be honest, quite a lot of people across the world doing that these days, and it's a very, very, very expert people across the world. So there's a lot of choice there. So it's really driven by what sector you're talking about and what choice there is. I don't have a problem with working with experts all over the world. I've worked with experts in a time zone that's been 12 hours away from me, so I don't have a problem with that. But obviously it is better to have someone more local because that's a bit more convenient. I don't know if that answered your question at all, but that's my thoughts.
Yeah, it does. Thanks, Ben. I think absolutely agree. We are in fact doing a matter where we have 7 different expert reports and they all have 7 different expertise. And it's very interesting to see that there's so much that happens in the same case, and there's so many pieces that experts can actually fill and come together and come up with, an answer which is independent, still founded in expertise and skills that come from outside. So I absolutely agree that it can be of many different shapes and forms. Vikas, I'll come to you now. In your experience, and since you are a practitioner, also arbitrator, and you have been an expert witness yourself for legal matters, how do you think the perception and relevance of experts to an arbitration differ from each of those perspectives?
Thank you, Ishani. Certainly, when you wear different hats, you're looking at an expert in multiple different ways. And I think Ben's given you a good insight as to what, say, a lawyer would expect and what an expert is required to do in the context of a legal case. I don't think I'll repeat that much. From an arbitrator's perspective, I think there's a couple of different broad themes that they want an expert to tick. They want them to be independent and they want them to be competent, and neither of which is always a given. Independence tends to be slightly harder to uh, displace, because I think given the very inherent nature of arbitration and that it's confidential, past engagements of experts tend not to be known. Unlike arbitrators, where there's an active requirement of disclosure, there is no such binding requirement for experts. So unless there's something glaringly obvious that comes out, it tends to be a little difficult to displace independence. And certainly as a lawyer cross-examining an expert, unless I really, really know that that's something that I can win, I don't quite venture down that path. But if, for whatever reason during the course of the process, the tribunal feels that a person's not independent, you've lost them. Like, no matter what you say thereafter, it becomes really hard to come back from it. So it's one of those extremely hard to displace, but if it does get to that point, then it's fatal. But I think where a lot of the expert's relevance and their role comes is actually in their competence. And competence can be established in two ways. One is with an extremely long CV with a series of credentials, or what I find most useful is how they've approached the problem in that particular case. So we've seen experts where they come in with, excellent credentials, like degrees and alphabets that you've not heard of being attached to their names, but ultimately their work product doesn't speak. So really then that CV becomes irrelevant. CV is a good starting point, because in any cross-examination you'd probably as a lawyer start with trying to establish, do you have relevant sector-specific experience? Do you have relevant experience in the kind of things you're talking about? But that's really maybe 2% of the time spent on their cross-examination. The bulk of it, therefore, comes down to the methodology they've adopted, how robust it is, and I think almost as important or more important is the data set that they work on and how robust that data set is. And almost all of the cross-examinations that I've done where we've been able to discredit the expert, it's been on that. Either that they've not taken sufficient knowledge, sufficient data to come to the conclusion that they've had, or that the methodology that they've adopted is not robust enough or is not stress tested well enough. So really, I think from the tribunal's point of view, that is where I focus on the most. And where people fail that test, you sort of discredit what it is that they have to say. Coming from the expert standpoint, and I think there's someone in the room yesterday who appointed me. And in that case, I really saw from an expert's lens how my testimony was taken to how my opposing expert's testimony was taken. And I think the difference was very clear in terms of, one, it was a 2-page report versus a 50-page report, and I'm not saying more is necessarily better, but I think you need to meet the requirements of what it is that is being asked of you. And as an expert, the more you try and avoid a question that's being asked, the more you try to explain that in an indirect fashion, the more obvious it becomes that you are not aligned with what ultimately your outcome is going to be. So the more long-winded an explanation, the less likely that you come across as being believable. So I think brevity is important, but brevity coupled with proper identification of sources. So whatever you're saying, and in fact I was having this conversation very recently with another colleague, every single line that in an expert report you write must be backed up by something. And for me, the less it is on my experience, my industry knowledge, the better it is. The more you're able to tie that experience with XYZ, source, ABC, document, or some protocol or some text, I think the better and more credible your report going to be. So really it's about making that report robust and making it more believable. I think that's really been my experience.
That's excellent, because I think I agree with every single thing, especially the last point you made on everything in the report is either sourced to something independent or an instruction that counsel have a good backing for. A lot of the times we see that we do work with instructions, but they are not founded in any evidence from the counsel side also, and then that's where we have a problem. And even the other point you made about brevity, I think it is so difficult to explain complicated issues in very simple terms, and I think that's a very big input that an expert can bring to the process. Before I move to Shreya, I want to come back to Ben. I think because you also have experience as the arbitrator and counsel, do you have anything to add to what Vikas said when it comes to looking at it from two different perspectives?
No. No.
That's not a problem.
No, Vikas has answered the question very, very well. I mean, I think, yes, I mean, the expert is not there to argue the case, but the expert is there to assist the tribunal and to educate the tribunal, as I've already said. And it very much turns off a tribunal if the expert is just being the advocate and trying to win you over, because it's like a red mist comes over them, and you think, well, what's the point of listening to this person if they're just going to argue something badly? I'd much rather listen to the advocate who knows what's going on and can argue the case better. You're there to actually tell me how you build this thing, how you do the analysis on this thing, and the arbitrators recognise that they have a big gap in their knowledge, and the experts are there to fill that gap. They're not there to persuade you the right or wrong of the case, because that's your job. But they're there to help you to grapple with these pretty complex problems that you may be facing. So yes, an advocate expert is really the wrong thing to have.
Completely agree on that. Okay, moving to Shreya. So Shreya, I know you do a lot of investment arbitration and shareholder disputes. And I also know that you've used experts from a lot of different domains. How do you find management of expert evidence different when you use, say, for example, a quantum expert versus, say, a delay expert or a technical expert? And doesn't matter like what the industry is, for example, or what the type of issue at hand is, or what is the type of dispute itself? Is it investment versus shareholder versus something else?
Thanks, Ishani. That's a great question, and a lot of things within it, so I'll try to sort of answer each of them. I broadly would categorize expert evidence into three buckets. One would be sort of your legal expert, just on the law. Second would be a purely technical expert on things like satellites or say concrete, which is something I've worked with before. And third is an expert who's sort of looking at a lot of factual documents as well, but also bringing in his own domain knowledge and condensing it into that field. So a classic example is delay, where you're looking at how the project was progressing, looking at a lot of extensions of time, how sort of at each level what was happening on the project, which is a lot of facts, but then also bringing your own knowledge of delay analysis and condensing it. And I think in a way that's what quantum experts do as well. Of course, you're bringing in knowledge of valuation techniques, but then you're also looking at facts, for example, of the company's cash flows and things like that. Each of them, of course, have their own nuances, but at least in my experience, I've found that from a management perspective, there are a few techniques which work in making expert evidence efficient across all these buckets. I can give a couple of examples where this seems to have worked very well for the case, but in some cases where it wasn't done, the expert evidence became difficult to manage. So the two things which I find where expert evidence has been efficiently managed is where the decision on how to manage expert evidence has been taken early on in the case, preferably in the first procedural conference or in the first procedural order. And that comes out in two ways. One is when expert evidence would be submitted and what order would it be submitted in. And the second is scoping of issues. So is it possible at every stage or as early as possible to really list down areas of agreement and areas of disagreement? And second, list down a list of common questions the experts will be considering. Because the more you can streamline this process with a list of questions, a list of agreement or disagreement upfront, the easier it becomes for the expert report to become more readable for the tribunal and the parties. Because then you know that these are the 5 areas we agree on, and therefore you may not even need expert evidence on it, but these are the 5 areas we disagree on, and this is how we disagree. we often see that in delay reports quite clearly, because effectively you're looking at, you may be looking at 75% of agreed facts and 25% areas where you disagree. But where I think that becomes harder, and perhaps Vikas can speak to that as well, is say a legal expert, where you may have questions you agree on, but ultimately how you analyze those questions or what tests you think that law provides for those questions is going to be difficult. So you can't really agree necessarily on too many sub-issues. You may be able to agree on the broader issues or questions. But I do think both scoping and timing are great ways to for a tribunal perhaps to try to manage expert evidence early on. I will give an example here of a recent case where we worked with a technical expert on, he was a forensic expert, and who had to sort of give his opinion on whether there were data breaches in the IT infrastructure. And in that case, the tribunal appointed its own expert, and I know we might touch upon tribunal appointed experts, but it all happened sort of very spontaneously. It wasn't something we decided at the start of the case. It sort of happened almost 1.5 years into the case. By that time, there was already a lot of documentary evidence. There wasn't sort of clear, no party was very clear on whether they are going to have a chance to oppose or reply to that tribunal appointed expert. So in a way, we had, say, in January, a tribunal appointed expert related procedural order. At that time, we just knew that there would be an expert appointed. And we were asked to share costs, but what happens in such cases often is that if a respondent wishes to be difficult, the claimant has to end up bearing the entire cost. So then it was an additional expert to bear the cost of. And both parties, of course, wanted to submit reply expert reports because they weren't happy with some portions of the tribunal appointed expert. So I just feel like in that case, it was a classic lesson of how some of the confusion and the cost-related issues could have been avoided if we had just agreed on a procedure early on. Or as soon as sort of, if not the first procedural order, maybe by the time you file the statement of claim, you know whether you are going to need expert evidence. So I think that timing and scoping are both sort of techniques which can help narrow down and manage expert evidence efficiently in all categories of experts. I know you briefly also mentioned about whether it makes a difference, the industry makes a difference. In my experience, of course, industry can bring its own nuances to selection of experts or the nature of expert report, but I don't think I have found that it makes a big difference to the proper procedures or processes internally to manage expert evidence. An example of where it made a difference to selection of experts, it was very interesting. We were doing a case during COVID where I think all of you know there was a huge short in sort of prices of commodities, right? And we had to find an expert who could opine on what was the trend in which the price of commodities, which are used to make a bar of steel, arose. Now that's something where, of course, knowledge of quantum does help, but of course, industry knowledge of that field and what is sort of the trend in iron ore prices or the trend in oil prices. That industry knowledge was actually very important to us, because the other side's expert was trying to make the point that all of this happened, but it was not because of COVID, it was because of some other causes. And therefore, knowledge of the industry and how similar things have happened, say 10 years ago or 20 years ago, became a crucial part of the expert evidence. So I think it's specific to your dispute. It's not necessary that in every kind of dispute, the industry brings in a lot to the expert report. That's been my experience. I would love to hear the panelists' views on whether they have found industry or geography making a big difference, because at least in the cases I have done, it wasn't that relevant a factor.
Very interestingly, I'm reminded of it that we had actually a matter which came in from the Bombay High Court, no, from a Delhi High Court, where the parties had applied to the court to have MCIA appoint an expert in a matter, because the parties couldn't agree on an expert, which was a very technical thing of finding somebody who knows how the financial management of a hotel works, running of the business. And the party involved was such that it was so litigious that they probably had exhausted all the experts in the field, right? So I think that's where institutions also then come into play. And I can tell you, Ishani, it was a great difficulty for us to find that expert. We finally did, and the matter then went on for it. But that was one classic example. We saw that how the evolving role and where the courts are now being approached to probably appoint, get an expert appointed in a particular matter.
think it comes back to the point of how specialized the expertise is that you're looking for. And something Ben said, that there can be questions which are routinely addressed by experts and you have a lot of options, and then there are questions that are so specific that it's very difficult to find those experts. We've been trying to find for almost a few months now experts in welding and process flow design, and we found people but not exactly what our client
Do you want to apply to MCI to help you find
Sure,
one?
I'll definitely take that up, and I'll take that offline with you. But I before I move on, did you, Shreya asked a question in case if you guys had anything to add on to geography/industry being relevant?
I think what I have seen in my personal experience is that not so much as geography, but industry does make a difference. I think the acceptability of having experts in the field of construction infrastructure is way higher, and you see them being used a lot more than probably what would you see them in your shareholder dispute maybe, or commodity disputes maybe sometimes as well. So I know, Shreya, you may have had a different experience, but at least my experience has been that industries have now evolved to whether have an expert or not to have an expert.
Yeah, I agree with that. Geography is less important. Geography can be important on a practical level in terms of having your meetings with the expert, but overall it doesn't make a lot of difference. But industry knowledge can make a difference. Particularly, obviously there are some expertise where industry knowledge is essential, like the satellite example I gave earlier, but when we're talking about, for example, a quantum expert who's looking at the accounts of a company, then if that person also has very deep knowledge of the particular industry, that can be very, very useful. Of course, on the other hand, if there are other factors involved in terms of choosing that particular expert, and maybe that expert isn't able to educate the tribunal in the way I've just described earlier, isn't able to present at a hearing in the way I've described earlier, so maybe those factors would override their industry knowledge. But the perfect package would be someone who has very deep industry experience on top of their knowledge of the economic analysis and presentation to the tribunal and everything else.
Okay, I actually want to come to a different point that Shreya made, and that was about having the timing and scoping done right at the beginning. We actually had a matter which went on for 4 years. 3 years into it, there was a liability hearing, and our client basically lost that. And they spent 3 years writing, we spent 3 years writing 3 reports, reply reports, etc., which is all basically not required. And at that time, although of course, it helped us, but we did think that if the liability, for example, the piece could have been carved out earlier, given how dependent the expert evidence was on some of the factual points, they would have really saved a lot of time and money on that process, the expert process. So completely agree on that. Actually, Neeti, I'll come back to you and on a point that Shreya made, which is about tribunal appointed experts. So have you seen, how often do you see tribunal appointed experts? We just spoke about an example, but any other examples that you haven't? Is it different, say, when it comes to domestic versus international cases? And what is your experience in managing them? Do you see a difference in managing experts which are appointed by tribunal versus parties?
Okay, I'm going to answer it in 2 hats, right? I'll wear my MCI hat and then I'll just talk about generally what my experience has been. MCI now is doing almost 80 matters. I don't think we've seen ever a single matter where a tribunal has appointed an expert. But I think what's increasingly becoming important, Ishani, is that where the parties now feel that if it's a 3-member tribunal, can we just not have an expert as a member of the tribunal itself? I do not know, I don't have an answer whether it is good to have, can you actually substitute one for the other? Maybe in certain cases, may not be in certain cases, right? Going to my personal experience, we had this matter I was doing when I was at the council in a matter which was construction of a hydropower plant. And I can tell you we spent almost about 3 months between the parties to decide who the tribunal would be. Because of course the claimants, we were the respondents, the claimants had already nominated a retired judge, not a surprise. And then we told our clients that this was such a technical matter on the construction aspect of it, that having an expert as a tribunal will indeed make a difference. But you know how if it's two Indian parties, I mean this was actually an international party, but still they had an Indian subsidiary as well which was involved into all of it. And they were like, no, we have a retired judge on the other side, we have to have a retired judge nominee as a respondent as well, right? So we had this back and forth and all, but I think somehow we as council prevailed over the parties and we said that no, we're going to take the chance and let's see. Hold behold, the presiding arbitrator is a retired judge as well. You can well imagine the sleepless nights I had from the clients to say that we really wanted you to have this. But as the matter actually progressed and we realized that the issues were narrowed down purely on the material to be used in the construction, how the construction actually was done, whether it was done to what the architects and other experts had provided the designs for, and we could see that the two judges were actually just alluding to the expert to give, to tell them that how it is doing and if they understand it. I mean, as a council, it took us almost 8 months, and my first experience of driving through a hydropower plant and the enormity of it, and we couldn't have got the tribunal to do the same, right? So for us to explain them all of it was much more difficult, but having an expert as a tribunal member did help. So coming back to your question to say that, do you see tribunal appointed experts? I don't think so, not in domestic arbitration yet, in my experience. Tribunal themselves being experts, yes, that's increasingly happening for sure. Parties appointing it, I think we still dealt with it, that it's slowly increasing. According to me, industry makes a difference. Management of them, I would like to believe that if it's a tribunal appointed expert, I think managing them also would become a bit more easier, right? It's a trust factor which is rather unfortunate, which comes in that you have a expert appointed by a claimant vis-a-vis an expert appointed by the respondent, and the issues that they're dealing with, how much can you hash them out, hot tubbing and all of that you use it. But I think management of a tribunal appointed expert is always easy and of course cost effective.
Ishani, can I give a counterpoint? And I think it's only healthy that there's a disagreement. There's actually 2 points there. I want to have a slight refinement or difference of view. On experts as tribunal members, I think in the example you gave is a good example where there would be a great member because their technical knowledge was relevant. And there, I don't think they had to do a lot of work to understand or to come to a conclusion of what is happening because they already have that knowledge. But I think where I might have some difficulties, let's say there's a delay expert or a quantum expert on the tribunal, because the whole point of a delay expert is the amount of work they do. And I mean, I work in the construction sector, so I know the amount of work that they put in. And it's only after that they've put in that element of work in that case, on that fact situation, that they're able to understand what the causality is, etc. So in that case, I'd be very hesitant to have a delay expert as a tribunal, because then if they come to a conclusion based on, we know tribunal doesn't spend as much time as experts would on the case, because they're given a more crystallized set of documents, whereas an expert can query documents, have a conversation with you, which a tribunal doesn't have the ability to do. I would be very reluctant to have that kind of an expert as a tribunal member, because then I don't know what they're thinking, I cannot cross-examine them, I cannot confront them. So for me, in delay and quantum, I think I'd be a little wary, but technical expert, I fully agree with you. On a tribunal appointed expert, what I wanted to say was, very recently when I was acting as an arbitrator, I rejected an application for a tribunal appointed expert. And I'll tell you a couple of reasons why I did that. In that case, the respondent hadn't paid the, surprise, the fees of the tribunal. The claimant was bearing everything. And the respondent wanted the expert appointed because they wanted the expert to prove their case. And there, we sort of came down and said, is there a reason why you cannot appoint your expert and come and give us that testimony for the claimant to discredit or challenge or whatever? And why is it that the claimant must bear the expense of doing that? Why shouldn't you? The other factor was, and I think it's a point that Shreya alluded to, was I'm acutely aware that if there's a tribunal appointed expert who comes in, and if you want to displace what they have said or you want to challenge what they've said, you invariably find yourself needing another expert to do that, because you somehow feel that if there's an expert who said something, if me as a lawyer says, no, that's wrong, or there's something wrong with the foundation, the methodology, you as a tribunal won't buy it. But if there is an expert in the field who comes and says, no, I have more grey hair, I have more experience in this field, I have greater research, you might believe them a little bit better. So I am instinctively very wary of tribunal appointed experts for that reason. And in terms of managing them also, I think it's a double-edged sword the way I see it, because with a party appointed expert, I think you can be a lot more free in your correspondence, communication, requesting documents. But with a tribunal appointed expert, almost always you want to feel like, you need to agree with the respondent what documents to give, what sort of information that the expert's relying on, etc. That I think makes the management of the process a lot harder. And if I am giving documents, I'm likely parsing it through an expert internally to figure out, what's the impact of it before giving it to a tribunal appointed expert. So I think even from a cost perspective, maybe on the surface, it might feel like it's one expert versus two that each party is appointed. But maybe in the back end, we are relying on experts to just ensure we are not feeding information which might fundamentally ruin my case.
At one point, I was yesterday when I was just reading up a little bit before the session, I came across a very interesting proposal about an expert team. So in tribunal appointed experts also, so to address, I think, some of the concerns you mentioned, Vikas, there's a proposal where the tribunal appoints a team of experts, which is where one party nominates an expert, the other party nominates its expert, and then they select a third expert. And that's a scenario where then the party would not submit their own expert reports, because they would have faith that this team sort of has their representation and has sort of selected a chair who they think is a good expert as well. So I don't know if we'll ever move to having 3 experts appointed by tribunal, where we don't even have one, as Neeti says sometimes.
Did that also talk about how did the cross-examination really take in? Is it the chairman's responsibility to be cross-examined by both the sides?
It did point out that as a question. It didn't answer it.
That's going to be interesting.
Thanks, all. That's quite interesting. I actually, our experience has been similar to what Vikas said. We have been appointed as tribunal appointed experts, and it has been a nightmare in terms of trust from both sides. We just don't get documents, we don't get information. We definitely know it's being passed through some expert internally before it comes to us, and it's all, it doesn't talk to each other when you look at both sides and what they're putting forward, and it's extremely hard to work with parties when you're appointed by the tribunal. But that's just been our experience in the one case we have been appointed by the tribunal. Okay, I will come to you, Ben, now, and just on the process further, I wanted to ask you, what should be the extent of the involvement of counsel in preparation of experts and expert reports, and how do you achieve the balance between briefing on facts and instructions versus maintaining independence?
Well, I mean, it comes back to the point about the independence of the expert and the degree to which they are seen to be arguing the case. I mean, on the one hand, it would be perfect for the experts to give their report to the lawyers, then the lawyers completely rewrite it so that it fits their case, so that it, or rather so that it is presented in the right way to the tribunal. But that runs enormous risk in the sense that the expert may not really grasp why it's been presented that way. It may differ from the expert's viewpoint on the matter. It may also mean that also the lawyers may misunderstand what they're doing as well. So, I mean, it does come with enormous risks. So, instead of doing that, you have to spend a lot of time with the experts to explain everything, explain the point of view of the client. But that also comes with enormous risk, because the more time you spend in the room with an expert, the more likely they're going to be influenced, and whether overtly or subtly, to present their expertise in a particular way. And that then undermines their independence. So you'll always get into a catch-22 situation here, because you want the expert to be closely aligned with the case, but not so closely aligned that they damage their own independence. So it's really hard, actually, and it depends on the individual expert, it depends on the dispute, it depends on the level of expertise required. We've got to talk about expert companies. Do you want to move into that? I mean, as we all know, the landscape has changed in dispute resolution. We now have companies like FTI, who are expert companies, usually carved out of the big accountancy firms for independence reasons, but actually have developed a level of expertise in every sense, in the sense of knowledge, subject matter expertise, but also expertise in the dispute resolution process. And they have raised the game in terms of the way they approach a case, the way they prepare for a case, the way they present the case. One might say, perhaps from a client point of view, they've also raised the prices. Because it's true that expert companies are rather more expert in negotiating their own fees than a professor in a university. But be that as it may, it has changed the landscape in the way that experts approach arbitration these days.
Thanks, Ben. Very interesting, especially on the first part. Before I move on, I just want to welcome our chief guest, Honorable Justice Dangre. Thank you so much for being with us, and we wait to hear from you very soon, ma'am. No, we have a few minutes before we can close. No, thank you. Yeah, thank you, ma'am. So I'll move to Shreya, and I'll come to the crux of the topic and the part where we say tips and best practices. So can you point us to some tips and strategies that you apply when you're dealing with expert evidence, both on your side and when you're cross-examining, say, experts on the other side? And what has your experience been?
I mean, that's a Pandora's box, I think. But coming to sort of, I would go more on tips rather than tricks. I think that's more on what I can speak to. Let's divide it into expert report stage and then second, the cross-examination stage, right? At the expert report stage, I think it's some of the points which some of the panelists have already covered, sort of being, spending more time on making the methodology robust, putting every sentence as something that's backed by documents, and really spending more time on that part of the report than setting out, say, your experiences and things like that, because ultimately the other side would also have that, and nothing is going to sort of ring on that. I think the part where the times where we've worked with sort of very good experts or more experienced experts, that's where the counsel's job becomes very easy, because all of that is a given. It's where we work with, say, less experienced experts is where we need to make sure that the expert report is solid, it's backed by documents, and really, I mean, think of what can be asked to that expert during cross-examination at the time of drafting the report itself. One other place where we've seen some contentiousness is where an expert was not instructed to, a quantum expert was not instructed to opine on the other expert's methodology. So for example, if the other expert has used X methodology and you've used Y, they've only given their quantum figure on Y, but not engaged with X at all. That if you adopt X, then what would be the figure? That can play out in two ways. In one sort of early cases I did in my current firm, the tribunal actually faced an issue where he wanted to understand how much would the quantum be if the other side's expert agreed with our methodology. Unfortunately, after 2 rounds of expert reports, there was none. And when, at the close of the hearing, the tribunal asked that question, the expert said candidly that I was not instructed to opine on it. If you'd like, I could do it now. And then we were faced with a situation where we want another round of expert reports after the hearing ends. At that stage, we were successful in excluding that application, because immediately after the hearing, the other side applied to say that we'd like to give more expert evidence. And that would have really meant another round of hearing. So we were successful in defeating it, but I'm not sure if that would happen in every case, especially where that expert evidence is crucial for the tribunal's determination. So I think that's on the expert report front. From a cross-examination perspective, I mean, I think the experts, at least the way we see it, are sort of masters of their field, right? And therefore, it's not, from a counsel's perspective, it's not like cross-examining a factual witness. of course, there's a lot more deference. You are the one who has to sort of master the material and try to point out flaws in the way the expert evidence is presented, or try to make it easier for the tribunal to understand why the disagreement should be in your favor. So I think from a counsel's perspective, the technique would be slightly different from a factual expert. And interestingly, one of the cross-examinations I had done involved a legal expert in one of the African legal regimes. And the biggest challenge for me was because that country was a sui generis system of law, so it was common law and civil law in that regime. The biggest challenge for me as a common lawyer was to sort of get over fundamental concepts of each of those regimes and then understand how they have been adopted in that country's regime. And one place where we felt our legal expert did a better job was that he took the time to explain to the tribunal how those elements merge together, because the tribunal was also not coming from the same legal regime. And I think that's something I appreciated from our expert in preparation, but I think the tribunal appreciated that a lot more, because the expert report and his testimony sort of was very helpful in understanding the basics, even if that didn't necessarily go into the 4 questions they had to answer, but I think it laid out the lay of the land for them very helpfully. So I always think the expert, of course, I mean, as Ben said, their role is to be independent, but they are ultimately there to help the tribunal understand technical issues, and the more they can do that, the better they would be for everybody.
I think the point about specific questions is very relevant. We've written reports where we were instructed to not answer a question. We were asked to answer 4 specific questions that the tribunal and the parties wanted to focus on, and that's all our report was. So it was actually a question and answer report, and that really helped them, because then we were not talking about things that nobody was interested, and it really helped the tribunal to focus on those issues. And the order was actually excellent when it came to talking about expert evidence. Before I move on, because I know that this is the crux of the topic, did anyone else want to talk about any tips or strategies or best practices?
I'm happy with what Shreya said.
Thanks, Neeti.
Sorry, the only small thing I will add is I think it's very important that an expert report is reasonable. The more an expert report is fully aligned with what one party is arguing without questioning, I think the more, when I said independence is a key factor, this is one very real way independence can be destroyed. So I think reasonableness is very important. Conceding at the right time is also very important, particularly in cross-examination. The more you are very adamant with your position, the less you come across as being reasonable, the less you come across as being believable. So I think those 2 are things I would add to what Shreya's already said.
Thanks, Vikas. They are excellent points. I'll come back to you, Vikas. So you have worked both on domestic and international matters. And what would you say are the key differences when it comes to using expert evidence in both of them? And any specific observations, including benefits or roadblocks that you face?
I think the use of experts is certainly a lot more in international arbitration than it is in domestic arbitration. And I think that trend is changing. And I don't think there's a historic reason to that. I think it's just been the experience of parties. There's been some reluctance on part of existing arbitrators to look at experts, because they look at them from the lens of it's a party-appointed expert, maybe they're inherently biased, etc. But I think there are now more seasoned arbitrators who are seeing through it, who are now analyzing the report and looking at the merits of it to check if it's biased and one-sided, rather than start with that assumption. But I think that's the trend we'll see.
I just have my last question to Neeti, but I do invite all the panelists to give some closing remarks if at all they want to add to what Neeti says. So I just want to ask you, Neeti, what can the entire legal community involved in the dispute resolution field do to make India ready for using expert evidence and effectively, and what do you think is currently lacking? And then on the flip side, what can experts do to make themselves a part of the growing India market as a hub for arbitration?
Thanks, Ishani. I have to wear my MCI hat and say that I have to finish it on time, because institutions have to make sure that you finish on time. So I'll give you just quick 5 things. I think first is events and webinars and sessions like this are very helpful, because I think we revisiting the issue again and again is also very important. Second is educating. Educating the clients, educating the lawyers as well, educating the arbitral tribunals. I think it's all required as a part of it that we need to do that. Third, I always compare it to institutional arbitration, and I'm sorry that I can't just leave that hat out even if I want to. I think we institutions can help you a lot as well, that we could maintain a list of experts and divide them in sector-wise, so that parties have an easy access to when they would want to have an expert appointed. Fourth, collaborate. I think experts need to collaborate amongst themselves to build in that culture as well. I mean, this is something, again, I wear from my institutional arbitration hat. We say that institutions collaborate because we want to bring in the culture of institutional arbitration. It is not one expert against the other expert or against the third expert. It's about the acceptability of the experts. And my last and the fifth point is that you can become a little more reasonably priced to increase the acceptability. Indian market is
I'm
a bit
looking
more
away now.
Indian market is a bit more price sensitive, and I think to get that inroad, it would probably help to, horses for courses, as they say. You can't do what you do in London to get it in India and say it's going to work. That's about it.
I can't follow on price when I can't. Lawyers are equally guilty of that. I think just one point actually, which is you refer to the legal community. I think it is we should be talking about the dispute resolution community, of which experts are also part. So, and I think lawyers shouldn't be so arrogant of feeling that the experts should be kept at arm's length. But we should also embrace each other, if you like. I mean, literally, no, metaphorically, but not literally, and recognise that we are engaged in a common endeavour, which is the resolution of the client's disputes, and ensuring that cases are presented in the best way to tribunals. So the more involvement of experts in events like this, the better, I think, and the more we as lawyers engage and attend expert events, the better, I think.
Okay, we are just conscious of time, so we won't be opening the floor for questions, but we will all be around if there are any questions at all. I now invite Vyapak to please introduce Justice Dangre. Thanks, everyone.